Hi, in this video we're going to talk about who should be your agent under your power of attorney. This topic is very important. In Florida, powers of attorney are effective immediately. What does that mean? That means that when you sign the power of attorney in front of a notary and the two witnesses, and you give your agent that power, a copy of that power of attorney, that person, the agent, can go to the bank and empty your bank account. So that's why it's very important that you appoint someone that you really trust, and it's going to be the job for you. So again, powers of attorney in Florida are effective immediately. So we don't have to wait for an incapacity or a letter from two doctors or a letter from an attorney or a letter from a financial advisor. No, Florida says powers of attorney are effective immediately when you sign it. Who should be your agent? Again, the simple question is a person that you trust. And also, but you need to think about who should be your agent more than just that. Let's say I'm married and I trust my wife, but my wife is also very old and she's probably very sick. Is she going to be a good agent on the power of attorney? Maybe not. So I probably should choose another person to be my agent. So even though I trust my wife, I would say no, I don't appoint my wife. I'm going to appoint my son under the power of attorney. And so let's say you have 2 or 3 kids. So who should be your power of attorney? Whoever you want. You can appoint your 3 kids. And you can say in the power of attorney that your kid can act jointly, or in other words, all of them should sign for whatever you need. The signatures of your 3 kids must be in the document, or you can say in the power of attorney that you can appoint either one of them. So whoever is available at that point can be your power of attorney. So can your agent be out of state? So let's say all of your kids are in different places. So let's say one is in Florida, one is in New York, and one is in California. How do you do that? So yes, you can appoint your children if they are out of state. There's no limitation as to geographic location. However, you need to be practical and say, what if you want the 3 of them to act jointly in your behalf? What's going to happen there? Well, you're going to need the signature of the 3 of them. And if you need the signature of the 3 of them, that may be a problem because of geographic location. So you need to send the document to all 3 of them and have the signature from the 3 of them to make that power effective. So you need to think about all the pros and cons of appointing your agents. Again, number 1 reason should be the person that you trust. Number 2 should be not only the person that you trust, but the person that will do the job for you. And number 3, how many agents you need under power of attorney, and that is completely up to you. Even if you have 3 kids, you can say, I trust only 2 of them, or my third kid is too busy and doesn't have time to do this. So there is no issue in appointing just 2 of them. The law also allows you to do what is called successor agents. So in other words, let's say you have 3 kids, and one of them is in Florida, one of them is in New York, and one of them is in California. So you can say my agent is my son in Florida, and you can appoint successor agents. In other words, you can say, if my agent in Florida is not willing or is unavailable to act, then my son in New York can do the job. If my son in New York is unwilling or unable to act, then my daughter in California can do the job. So you can develop any formula that you prefer in consultation with your attorney, of course, and come up with the best solution for your particular case. So that's why it's very important that you discuss your situation with your attorney before signing before preparing this document. So again, keep this in mind. And in the next video, we're going to talk about more different things about these details that will be good for your situation. Thank you very much.